I think you all agree with me when I say that there is certainly no shortage of topics that we could talk to you about today, a number of which could have an entire presentation dedicated to them. However, we do only have an hour, and I'm sure you'll be sick of us talking after that hour. So what we wanted to do is to take you through some market trends for FY 2023 as we see them, some key employment opportunities and challenges for the year ahead, and 5 topics that we see playing a key part in the year ahead. And of course, we don't have a crystal ball, but we do have a sense of the kind of topics that are shaping to feature on the agenda. And finally, we couldn't ignore the fact that we have a new federal government, with Labor winning the election for the first time in almost 9 years. We will therefore take you through what employees can expect from this new Labor government. So turning first to market trends, we're almost 2.5 years deep into COVID and are certainly continuing to see the ongoing impacts of that in many respects, and particularly in terms of the highlights on this slide. Border closures and disruption have meant the war for talent is escalating in light of workforce shortages and retention challenges. And finally, hybrid working models, which largely came about as we dipped in and out of lockdowns, are continuing to evolve. So I'll touch on each of these briefly. Recruitment and retention. The Great Resignation has and will continue to have a significant impact on workforce management, with increasing resignation rates leading to a war for talent as employers compete for skilled workers. In Australia, data indicates that 38% of workers want to leave their current employment within the next 12 months, and 73% of employers are concerned about staff shortages. This stands in stark contrast to resignation levels in the lead up to 2021, with just 7.5% of workers having changed their jobs in the 12 months preceding February last year. Employers will need to think about how they will attract and retain staff, ranging from competitive remuneration and incentive arrangements, health and wellbeing initiatives, and of course, flexible working. On the hiring side of things, in an environment where employment contracts are likely to be more heavily negotiated than usual, it is important for employers to carefully consider how they will position any additional benefits to be offered to employees, noting that codifying current policy benefits or entitlements that may be based on salary at the time of an exit or an employee's length of service have the potential to cause legal and financial headaches down the track. On the exit side, post-employment restraints and protecting confidential information and IP will take centre stage as employees move more readily between organisations, including to competitors. It is important in this context to check whether employment contracts need a general refresh to ensure contractual provisions are sufficiently robust, enforceable, and continue to apply post-termination in order to protect legitimate business needs. In terms of labour supply issues, the impact of COVID-19 infections on the workplace has resulted in widespread staff shortages, and we expect that the pandemic will continue to disrupt labour supply, with variants and waves of infection affecting participation in the workforce. And I'm sure you can all appreciate that it's now not only COVID-19 infections impacting labour supply, but also the flu. Employers need to manage their workforce to account for employees who cannot work due to infection and mandated isolation requirements, even though they have relaxed significantly. It might be necessary to implement flexible working arrangements and rostering changes while adhering to any obligations under applicable industrial instruments. Employers should consider how to incentivise workers within this framework as well. For example, some organisations have brought in various benefit programs, such as the introduction of extra paid leave entitlements, to allow their employees to get vaccinated or boosted during work hours. Investing more time generally in health and wellbeing activities is also on the rise. Labour shortages are causing employees, particularly in healthcare and food production sectors, to be pressured into returning to the workforce after being diagnosed with COVID-19 or classified as a close contact, although that's less relevant at the moment, and perhaps they're being encouraged to come back prematurely. Employers need to ensure they comply with the current guidelines for returning to work and their obligations with respect to health and safety. Consideration can also be given to strategies to deal with resourcing challenges such as utilising labour hire arrangements for a temporary period. While a number of these labour issues now seem under control with isolation rules changing, new variants may present new challenges. Now, this is something that most, if not all of us, will be very familiar with, I'm sure, and that is hybrid working. The evolution of the pandemic has caused a global shift towards a hybrid working model, with employers and employees alike favouring work from home arrangements. The ACTU's Working from Home Charter has even called on employers to provide employees with allowances or reimbursements for work-related expenses, such as water, electricity and gas, stationery, equipment, amenities, telephone and internet expenses, as well as promoting the right to disconnect for workers. The blurring of work and home life has also created new legal challenges in terms of what constitutes the workplace, including in the context of an employer's obligation to provide a safe work environment and regulating out of office conduct such as bullying and sexual harassment. A key challenge we see ahead, and which clients are already experiencing, is encouraging workers to come back to the office, even if on a hybrid basis. With a number of employees happy at home, there will be a question around what an employer's policy should be in relation to return to work arrangements, and what action should be taken where staff fail to comply with that policy. To mitigate against this, organisations should have a clear strategy and process in place, and we will talk a bit more about this later on. So some of the opportunities and challenges that we've identified for employers for the upcoming financial year are set out on this slide. The first being diversity and inclusion. In 2021, we saw a multitude of reports regarding diversity and inclusion in the workplace, and many of these reports saw the gathering of diversity and inclusion data that can be used to better existing workplaces. Globally, there's also a push for diversity and inclusion to be addressed through legislation. For example, in the UK, they've introduced legislation surrounding the ethnicity pay gap reporting, and they already have in process legislation for gender pay gap reporting. In the Netherlands, with the introduction of transparency rules for equality on listed and large companies. And as we will discuss later, gender pay equity is also one of Labor's IR policies. The next two are related and are psychosocial hazards and workplace wellbeing. Throughout 2021, mental health and wellbeing in the workplace understandably received an astounding amount of attention from policy bodies, safety regulators and employers throughout Australia. Shortly, Stuart will briefly discuss the various regulations and codes of practice relating to managing psychosocial hazards in the workplace. Another challenge in this space is balancing mental health and the new light on the prevalence of sexual harassment. It is important for organisations to recognise that sexual harassment as a real and prevalent psychosocial risk in order for it to be addressed appropriately. And we expect that there will continue to be more regulatory activity in this space throughout 2022. The next is ongoing risk assessments and COVID-19. As I'm sure you're all aware, all organisations must assess the risk to their workers that COVID-19 brings and implement controls to manage those risks. A documented risk assessment is one of the easiest ways to do this, and to be able to evidence that you have done so if you ever needed to. As Omicron has significantly increased the number of cases in the community and changed the risk profile for workers and organisations, we do recommend that you review your risk assessments to take into consideration the changed nature of the risk of Omicron and any new variants brings, and assess whether the controls you have put in place already to manage these risks are still appropriate and effective. Your COVID-19 risk assessment should not simply be a set and forget, but a living document that is constantly engaged with, reviewed and amended. Having a well-drafted risk assessment will also assist with the rollout of considered vaccination or mask-wearing mandates, and they will then be based off the risks to workers and the control measures that are available to be put in place. Many organisations have already put in place mandatory vaccination policies. Some are still considering such policies or are still in the process of consultation. Employers who do implement such a policy, though, will need to ensure that they comply with their obligations to consult and with any applicable government directions. Employees also need to ensure that any directions it gives to its workers are both lawful and reasonable. COVID-19 has also forced organisations to consider flexible working arrangements, and we consider this to be both an opportunity and a challenge for organisations. While it presents an opportunity for organisations to rethink the way in which they work, it can be difficult for organisations to adapt to flexible working. And one such challenge will be differentiating those measures that are necessary and prescriptive from those that are being encouraged, recommended, or even suggested out of an abundance of caution. The next one we've got up there is unfair dismissal claims. As a result of the increase in COVID-19 policies, we have already seen an increase in unfair dismissal claims from workers who have refused to get vaccinated when such policy is implemented, or who fail to follow a lawful and reasonable direction. The Fair Work Commission has been inundated with such cases since the start of the year, and they will no doubt continue. Helpfully, all the cases that have been decided by the Commission, and there are many, are overwhelmingly in favour of employers. In our experience, this fact is something that both conciliators and members of the Commission are making clear to the parties, particularly to the applicants at the outset of the matter, to encourage resolution and in some cases to put pressure on the applicants to discontinue. Notwithstanding this, organisations should still take steps to proactively manage these unfair dismissal risks by making sure they have robust defensible policies in place, supported by key risk assessments, in the event that they mandate vaccination or even implement a RAT regime. They should ensure they understand and comply with any consultation obligations, ensure they comply with any privacy obligations as well in relation to the collection and storage of sensitive health information, provide employees certainty and security around the approach the organisation is taking to manage its COVID-19 risks, and ensure it is taking steps to support all of its employees and its senior executives to reduce the risk of COVID-19 fatigue and burnout. The final one we've identified is the change in government, which we consider is likely to present both opportunities and challenges for employers. And as I said, Stuart will discuss that in more detail later on. So let's now turn to the top 5 items to look out for the next financial year and where we think there will be the greatest focus, both in a legal and regulatory sense. So the first is COVID-19, which I will mention only briefly as I have already spent a bit of time talking about it. Dan will then take you through whistleblowing, casual employment and other sort of related engagement issues and wage theft, and then Stuart will deal with health and safety and then finish off with the Labor government policies. So COVID-19, as we all know, the pandemic continues to present challenges for employers in 2021. And as states and territories moved from an elimination to a suppression strategy, businesses are having to operate in new and delicate conditions. So it's likely that in the second half of 2022, regulators will continue to promote and enforce COVID-safe measures to suppress outbreaks related to new and emerging variants of COVID-19. So some key issues that we think employers need to continue to consider include the public health orders and directions. I think we're all well versed in the various public health orders and directions mandating vaccination, isolation, quarantine, check-ins, which thankfully here in Victoria we don't need to really worry about anymore, access to premises and mask wearing. Within each state and territory, they've been ever changing, and it is important for businesses, particularly those that operate nationally, to ensure that they remain aware of any updates to these mandates and abide by them. The other is return to work arrangements. Returning to work post-COVID will not be a flick of a switch, and I think we already understand that now as we're trying to return to the workplace. It will involve a gradual, phased and staggered return of staff, And some of the examples of return to work approaches that we have seen so far include splitting the work teams into roster A and roster B, with one team coming in one week and the other working from home, then swapping over the following week to reduce cross-pollination. Having a minimum set number of days in the office and at home, for example, 3 days in the office and 2 days at home, with common days so that you can have meetings and face-to-face discussions and the like. Staggering start and finish times for staff to avoid peak hour commuting, and also allowing staff to only return to work when they feel comfortable and are absolutely required to do so. For example, to attend a meeting, an event which cannot be otherwise substituted by video conferencing. So I think the short of it is that there will be a whole range of different arrangements that might suit your business, and you just need to really have a think about and find the right balance as well. I've already spoken about labour supply and workforce shortages, so I won't go into that again. And then finally, in terms of mandatory vaccination policies, we suspect a lot of work has already been done by most organisations in this space by now, but there will be more to consider, including to address issues such as updating the definition of fully vaccinated to include booster shots, which may then lead to further non-compliance and dismissals, and may also mean that there's further consultation that you need to engage in. The effectiveness of vaccines against any new virus strains and variants, and how that may impact upon reducing the risk of COVID-19 transmission in your workplace, and also the potential removal of government mandates and directions that many of us have relied upon in the past. So that's just a brief snapshot of some of the issues I think you need to be thinking about already in terms of COVID-19. And that is all from me, and I will now hand you over to Dan.
Thanks, Al. I'm going to talk about a few areas. First is going to be whistleblowing, and I was actually thinking about whistleblowing today. I was thinking about when, it was probably a few years ago now, the laws came in under the Corps Act that everyone, over a certain size, there are 3 criteria, and if you meet those, you have to have, I think it was 2 out of 3, you have to then have a whistleblowing policy. And at the time, Katie Cameron, who's here, and I did a lot of work with a range of people, and some in this room, on whistleblowing policies. But I think at the time, it was the rush of, let's just get a whistleblowing policy in. We've ticked that box and we've now moved on. And I think we had a query about, is this going to be something that is really going to be used? And is it going to become important? Is it going to be something that becomes ingrained in businesses as part of their operating model? Or is it just going to be something that we've ticked the box, we've got a policy, we've complied with that, we've moved on? The short answer to that is that whistleblowing complaints have obviously continued to, I'm not going to say skyrocket, that's probably a more alarming word, but they have risen significantly. So in FY 2019, there were 278 whistleblowing disclosures to ASIC. In FY 21, that went up to 817, so almost trebling of the number. Don't have the figures yet for FY 22, but the expectation is that that number will continue to rise. And what does that say? It says that people are getting the message and people are using it. And so whistleblowing is not just becoming an issue of, well, this was as I think Al used the word, sort of set it and then forget it approach. We've got a policy in place, great. It's going to continue to be an ongoing part of any organisation of any appreciable size. The issue on whistleblowing is there is a significant amount of non-compliance even with people who have policies. And in fact, ASIC have recently done an analysis of policies, and they, in a review of a sample, and it was only a sample, but it was quite a decent number of policies they reviewed, they found that 40% of policies didn't comply with what they say are the legislative obligations. And those of you who might recall, when we help people with putting their policies in, did seem to be a view about what the legislation actually said and then what ASIC said it said. And what ASIC said it said was much more than what was actually in the legislation. And I think most of you would recall that the advice that people like us would have given you at the time would have been, it kind of doesn't really matter what the legislation says, because if ASIC says it means this, that's what they're going to do. And so you've got the choice of, yeah, you can be the test case and you can fight them on this and say, we think you're wrong, or you can just comply with perhaps the higher standard that ASIC have set. So they say 40% of the policies actually don't currently comply with the obligations. And they say that one of the primary reasons is because they don't clearly outline how staff can report misconduct and how they qualify for legal protection. And they're probably, you would think, two of the more important things in your whistleblower policy. How can you report it and how you qualify for protection under the whistleblowing laws. So ASIC have publicised this. They wrote an open letter to CEOs of organisations. That open letter is available on the ASIC website, and it encourages essentially all organisations to more properly engage with the whistleblowing system. And in particular, they encourage a range of things around reviewing the policies that you've put in place and making sure that they're compliant, but also what are the systems and processes you have in place to ensure that whistleblowing protection is embedded into your business. It's not just a policy that sits there on the dark corner of someone's intranet. We've got a policy, it's there, no one ever looks at it, but it's there. They want you to focus on how you actually embed it into your organisation's risk assessment strategy. So there are a number of suggestions we have in relation to that. They are all consistent with what ASIC would say. The first is reviewing the policy that you have, making sure that it is compliant with the Act, the regulatory guide, which I think, as I said before, probably goes significantly further than what's in the actual Act, but that is the basis that ASIC will say you have to comply with. And then the comments that have been made in that open letter to CEOs. One of the aspects that ASIC are particularly concerned about is how do organisations triage whistleblower complaints? So how do you respond to it? Do you have systems and processes in place that mean that when issues are raised, you can work out promptly and discreetly and confidentially and all those things, whether this is a whistleblower matter? If so, you put it into that stream. If it's not, is there another mechanism for people to raise issues? And which sort of disclosures attract the whistleblowing scheme and come within your policy? Obviously, considering your organisation's risk assessment strategy and how whistleblowing comes into that, most organisations of any appreciable size will have a broader risk assessment strategy, but they'll also have those in particular areas. So whether or not you have a broad risk assessment strategy or policy, having one in place for your whistleblower protections is important. The engagement between the policies and management systems is, I'd probably put it as a way of how are whistleblower policies operationalised? It's all very well to have a policy. Does it integrate with the way you do business or the way you run your operations? And that is really important because ASIC's view, and ASIC has said that they will. They don't say it in as overt a way, but I think the way they're putting it is the gloves are off. We've given a period of time for people to get these policies in place and systems and processes. They were pretty lenient at the start. They gave quite a strong, I think it was quite a reasonable grace period for people to sort of be non-compliant. Their view now is everyone should be compliant and we're really going to start enforcing this. And it's not just going to be about the terrible cases where someone is a whistleblower and is treated badly and you can be subject to huge fines and all of those sorts of things. It's going to be about the cases of people where there might not be any whistleblowing complaint. There may be nothing that is raised, but it's the failure to have a policy or a compliant policy and have systems and processes. And we're expecting ASIC to be out there auditing, and we're expecting them out there to starting to take enforcement action against organisations, even if they haven't had a whistleblower complaint that's been handled badly, the fact that they don't have the policies or processes in place. And the last thing, obviously, is considering training and awareness measures. And again, it was something I think we did a bit of, worked with a few organisations around a sort of training piece and an awareness piece at around the time we introduced those policies. But I think most organisations, if they were being candid, would say that that activity has dropped off. So it's sort of your time for it's not quite an annual refresh of your training and awareness, but it's probably a timely moment to say we need to look at what we did in the past and either replicate that around training and awareness or improve and enhance upon it. The next area I was going to talk about was a broad area called worker classification, and we've divided this up into 3 areas. I'm not going to go too much into the detail of the cases because most of you, I think, would be aware of very significant cases. You had Workpac and Rosato, the case around what's a casual employee. You had the Jamset case around independent contractors. You had the CFMEU case and personnel contracting, around those odd co-arrangements. All of those cases have been, if you could describe them in a general sense, have been about, well, maybe I'll put it this way, others might disagree, about the fact that courts, particularly the federal court, have over the years continued to look into the substance of relationships, whether is it a casual employment relationship or is it permanent? Is it a contracting relationship versus an employment relationship? And say, we're not really that worried about what's on the written paper, the contract between the parties, how they started. We're more interested about where they are now, how it's developed, what it is, how it is in operation, and a real sort of approach of current day substance versus initial form, and say forget about the initial form, focus on the current day substance. There's been some high watermark cases in that really pushed the boundaries and sort of suggested that you had to be a contractor, for example, you had to have an entrepreneurial business that was sort of out to the general public. You had to have a website, you had to have a shingle or a shop front. That was the sort of test of being a contractor. So anyone who provided their services without there being sort of open to the general public couldn't be a contract, they had to be an employee. The pushback from the High Court in these cases has been around these arrangements are contractual in nature. Fundamentally, at the heart of them, they have a contract. Look to the contract and see what the contract says. And if the contract says you're an employee, then you're an employee. You may work for 20 years as an employee, you're still an employee. If it says you're a contractor, you work for 20 years as a contractor and you have all the benefits of being a contractor, income splitting and being able to claim business expenses and all those things, don't come to the court 20 years down the track and say, actually, I was an employee that whole time, because the contract said you were a contractor. So the court did, in the Odco sort of decision, talked about sham arrangements and saying, obviously, you can set the terms, and the terms themselves either might disclose a sham arrangement or might disclose that on their face, even if you call them a contractor, they are an employee. But absent that, if it's a contract that looks like a contractor arrangement that has all the hallmarks of it, if it's a contract that has all the hallmarks of being a casual engagement versus a permanent one, then the court should respect that and apply that. Now, I think from an employer sense, that was always something that made a lot of sense because it means you have certainty. When you engage someone in a particular way, what you're really after is the certainty that that engagement will continue to be the engagement that you have, and you don't have to constantly check and recheck how the relationship has developed to work out whether it's morphed into something different, which was never something that was contemplated. Where we are going to run into some issues, and certainly we think over the next couple of years, will be that there will be a legislative agenda of the new government that will restore what they would say some of the fairness to that situation, because I think the statements that have been made, certainly by the incoming Minister for Industrial Relations, has been that some of those sort of focus on what is the contract, and you set the contract and that for the rest of your life determines what the relationship is can be unfair. And it's possibly right. It could be unfair if the relationship morphs into it. The question is, what are they going to do about that? What could they do? The casual conversion provisions are a good example of what you can do, which you can say if a casual engagement really morphs into something else that should be permanent, you have a casual conversion provision. It's possible we might get something similar from a contractor to employee conversion. It might be that you might get a system built in where someone who believes that a contractor relationship has really become an employment relationship can go and get a ruling that they are in fact an employee. Now that would be a better system than one that says retrospectively a court can look back and say for the last 20 years you've in fact been an employee rather than a contractor. So having a system where you might apply and not retrospectively but prospectively convert from being a contractor to employee if you meet certain indicia, that might be a better system because at least it will give people certainty that they haven't got all these accrued liabilities from the past that they never knew they had. It does raise the issue about forcing people into types of relationships that they never envisaged going into. So if you're a business that doesn't want to have any employees, would prefer to have contracting relationships with everyone, you could end up in a situation if you have such a regime that you will have a whole lot of employees, a bit like if you're a business that says, I only ever want to have casual employees. You could, with casual conversion laws, end up having a whole lot of permanent employees, notwithstanding that not ever being your intention. But we'll wait and see the laws because the statements that have been made have largely been broad statements of policy or at least endorsements of statements of policy from some of the trade unions who've had particular concerns. And particularly in this area of the gig economy, that's been one of the areas where the statements have been very general in nature about ensuring, we need to consider fairness in the gig economy. We don't really know what that's going to look like. It's possible that we could end up with a hybrid model, which is you're not quite an employee if you're a gig economy worker, but you're not quite a contractor. You're somewhere in between. You're a contractor, but a contractor who has some basic minimum rights. That's one model that is being looked at. The other model that is being looked at is moving almost to a sort of more full employment model. There is no contracting arrangement in that sort of gig economy. It's really challenging to work out how that will work because the gig economy, it's one of those things that crept up on us. It certainly crept up on the lawmakers and it crept up on employment lawyers and it crept up on HR people and it crept up on all the people who generally like to think about, how you structure arrangements, etc. And it's become so embedded now that it's very hard to change the way that is. So it's a model that has no employment in it and that has generally been reinforced by the courts with the cases that have said, look to the primacy of the contract and what does the contract say. So we certainly think that that's an area that will be one to watch, certainly in the next year. I suspect in the next 1, 2, 3, 4, 5 years, because some of these things are not going to be things that are going to be easily able to be bitten off by a new incoming government. They might be a sort of second term agenda on some of them, and some of those challenges with the gig economy might be in that space. The last thing I want to talk about, and I'm going to hand you over to Stuart, is wage theft. And I probably don't need to talk too much more about some of the background of wage theft because I think it's been a very much a hot topic for people over the last number of years. What we did want to talk about briefly was the Senate inquiry and the finding of the Senate committee about wage theft, and in particular they made a number of recommendations. One of which was criminalise the Fair Work Act, change the Fair Work Act to criminalise wage theft. The incoming government have said that whatever they do in this space, it will be complementary to and won't override or supersede state laws. And that's quite an important issue because in places like Victoria, where you do have a wage inspectorate, we have criminal wage theft provisions. There's a query about how whether those laws are actually constitutionally valid when you consider that the Fair Work Act for most employers and employees deals with the issue of payments and the issues of consequences of payments, and they have civil penalty provisions and they have a whole range of things. And there's a real constitutional question about how a state-based system of laws that deals with Commonwealth laws which seem on their face to want to cover the field, whether they're valid at all. And no one's really I don't think anyone's actually taken that position on with the laws in Victoria yet. And to be fair, the Wage Inspectorate has been much more interested in long service leave at the moment. That's their main area of interest, and it's an area they clearly have jurisdiction because the Fair Work Act carves that out for the state. So, changing the Fair Work Act to criminalise wage theft, increase civil penalties, establishing a small claims tribunal so people won't have to go through courts to pursue wage theft, and including superannuation in the NES. And those things will all probably all be adopted. I think the reality is that the statements certainly from the incoming government have been that when things like this, they are going to look to implement all of the recommendations. Now, we'll wait and see whether that's the case, because some of them are going to be more difficult to do. But I think they would certainly say that they've got a mandate to do so. For all businesses, wage theft and more generally underpayments of remuneration have been a significant issue, and there are lots of compliance issues that we all have probably dealt with. Some of us had to deal with them every day in matters, and others have dealt with them occasionally. And hopefully you're in businesses where you haven't had to deal with them every day. But I doubt there'd be many people in many organisations who would say that the spectre of having an underpayment claim, historical or current, come to light hasn't been something that's played on their minds. Most organisations, whether it be in government or in private sector, and even those employers who pride themselves as being good, generous, paying well above award, etc., employers would still be worried about the issue of compliance with obligations to pay wages. So, what do we do for key compliance steps? Obviously, having the systems to record hours worked, education and delivery and allocated hours, terms of engagement, clear guidance and guidelines around the use of casual staff, because that's a particular risk area, training for managers and supervisors, which I must say is not an area that a lot of businesses have put a lot of time into until they get hit with a large prosecution from the Fair Work Ombudsman, and then as part of their compliance program or their enforceable undertaking, they say, oh, we're going to train people and we'll do this. So it's quite a reactive thing, and I think that's something that organisations need to look at. Auditing, mechanism for staff complaints and concerns, and an increased focus on government. And they're all really going to be significant areas. We think there's going to be an increase in the states that haven't got wage theft legislation taking them up, but also the ones that have ramping up prosecutions. We think that is going to be an agenda item, particularly now that we have a federal government that has said they're happy for the state regimes to continue to operate, and whatever they put in federally will be complementary to that. So there'll be no questions about constitutionality. It'll be considered to be two complementary programs. Wage theft obviously is a phrase that's bandied about, and it is used by different people to mean all sorts of things. There are some people on the scale who call any underpayment wage theft. The definition of most, commonly used definition is actually something that's deliberate and dishonest. So withholding of wages, superannuation or entitlements, or in falsifying of employee entitlement records to gain a financial advantage, or avoiding keeping records to gain a financial advantage. So they're the three areas I was going to talk about. It's going to be a really interesting couple of years. I don't remember, just before I pass you through, I don't remember if any of you came to our seminar that that we had back in 2007 before the Kevin 07 election, and we had Bill Shorten come and talk about what they were going to do in government. And it was fair to say that they had a really strong agenda when they came into government, and particularly in our space, employment law, industrial relations. They then pursued that, and we got the Fair Work Act. And that was a significant change in the way we operated. Not sure we're going to get that this time around, but it's an exciting time to be an employment lawyer. It's probably going to be a very lucrative time to be an employment lawyer, potentially increased industrial disputation, lots of interesting things. I'm not sure what's going to happen in health and safety, but Stuart's going to talk to you about that.
Thanks, Dan. Good evening, everyone. Yes, obviously part of the Labor platform was employment security for employment lawyers. Before we jump into that, because rumour has it that we have had an election, and I know you are keen to hear about what we know about what's likely to happen. One that has gone under the radar, though, before we get into that, is some changes in the Victorian OHS Act. And one of those is a set of regulations that have been out for about a year with consultation. Consultation concluded. I think it is an absolute given that before the next Victorian election, so for those election files, don't worry, we've got another one coming pretty soon. We'll get some ads on TV pretty shortly. But there's a set of regulations that will be passed, and they represent this continued journey of taking things that we traditionally thought were employment issues rather than safety issues. So things like performance management, stress, anxiety, bullying, which is now quite well accepted as a safety issue, but broadening it and treating it as a safety issue. So these regulations will flesh out and provide more detailed obligations on Victorian employers to deal with psychosocial hazards. And you can see on the slide there a number of the key things that are required: identification, elimination, reduction, review. So for those people who practice in the safety space, that kind of methodology of risk identification and assessment and controls is your stock in trade. For a lot of HR practitioners, that's not the way they've gone about managing or preventing these issues. One of the key things it does, though, is it requires a written prevention plan for certain sub-part of psychosocial hazards, those that involve aggression, violence, bullying, or exposure to traumatic content or events, and sexual harassment. And a lot of employers don't have such a thing at the moment, and there'll be a need to put in place a clear prevention and risk mitigation plan. There's significant reporting. If I was sitting on a board, I'm going to need to know about this. There's going to need to be increased reporting to me, but there's also going to be increased reporting to WorkSafe. One of the things that appears on its face is the obligation to report to WorkSafe is not, for example, where there's a complaint of bullying that's been established, but just where there's a complaint of bullying. So think about that in some of your larger employers. Every time there was a complaint of bullying or sexual harassment, that you had to notify WorkSafe in the same way that you do at the moment if someone suffers an electric shock or a fall from heights. At the very bottom there's a couple of changes that have been made to the OHS Act already that are in place, and continuing one of Dan's themes, the continuing merger of what were traditionally independent contractors and employee concepts is continued here in the OHS legislation amendment. So if I simplify it, the duties that you owe to your employees, you also now owe the exact same duties to labour hire workers. Doesn't mean the labour hire company doesn't also owe duties, but it does mean that you need to engage, cooperate, coordinate, and if you're the larger of those two parties, it's going to be your safety system, your safety obligations that you're going to have to be applying. But I do know a number of people have been keen to hear about what Labor's going to do. Segueing from the psychosocial, my memory of this election, and I've never seen more engaged people, but my memory of this election is I'm in Kooyong. I've been waking up in cold sweats with pictures of Josh every 5 metres and pictures of Monique Ryan every 2.5 metres. I don't know if anyone had the pleasure, but there were literally about 5,000 pictures of each of them. And so I've tried to block out the election, but apparently we had one, and apparently we had a change of government. In preparation for this, I did ring Albo. I rang Albo as a fellow Hawks supporter. So for those who didn't know, Albo's a good bloke. He supports Hawthorn. And I rang him and got an insight into some of these issues. It's fair to say there's no one document that you can find at the moment, whether it be on the Labor website or anywhere, that actually sets out all of the policy position of Labor in the employment space. There's about 4 or 5 that need to be brought together. But I have distilled them down into 4 key themes. And none of these will surprise you, but they are themes focused on gender. So addressing the gender inequities in different ways to ensure clear parity across genders in particular. Insecure employment, whether that is casuals, gig economy workers, smaller individual independent contractors, and trying to level the playing field for them and remove some of the differences and possible exploitation. Compliance, wage theft being paramount amongst those, but that's not the end of compliance. And lastly, the one that is obviously getting a lot of attention at the moment, that to be honest wasn't really getting attention 3-4 months ago, which is obviously wages, cost of living increases, and revolutionising or changing or doing something with the bargaining system that it seems there is a common understanding or a common view across peak employer bodies, unions, government, business, that it's not delivering productivity benefits, it's not delivering wage increases, and we need wage increases and we need productivity benefits. So 2 slides, we've tried to just distill all of this down. We have a lot of breadth at the moment from Labor. We don't have a lot of depth on some of these issues, but I just wanted to call out a few things for you. Increased wages, you've obviously seen this week, submission by the government to the Fair Work Commission to support a wage increase that will keep pace with the current spike in inflation. Hopefully it's a spike in inflation, but also to award wages. And the main impact for most of our clients who have enterprise agreements is not the immediate hit to minimum wage, but there'll be impacts on bargaining. Some of our clients have bargaining increases tied to CPI. They're trying to work out how to change that at the moment. And we have others that are obviously looking to a sustainable wage increase that sees their employees with capacity to meet their costs of living, but doesn't bankrupt the business. The casual gig workers, Dan's already mentioned. I think, notwithstanding the best efforts of the High Court to provide, I'll call it right-wing certainty. So we've had a period of right-wing certainty for about 6 months. That's going to be undone. So we will have a change in legislation. There'll be a change in the definition of casual. So moving away from a casual being someone that's got a contract that says they're a casual to someone that has a more substantive test. I think the real issue will be whether that test is along the lines of pre-risato, i.e. that in substance they're a casual, there's no firm advance commitment, or whether it's going to go further and actually say you can only employ a casual if they're truly ad hoc, truly intermittent. And if they're not those things, then we're going to preclude you from employing them as casual. So we do have a number of clients who have cyclical businesses who, not because of ideology, but because of some of those challenges, do employ significant cohorts of casuals and fixed termers. And at the moment are looking at the structure of their business, the structure of their and the makeup of their workforce to anticipate that some of the flexibilities that casuals currently provide won't be available to them any longer. Dan's mentioned labour hire. The other thing they're proposing to do, like we have in Victoria, is a national labour hire licensing scheme. The only thing I'd flag to you about that, learning from the Victorian experience, is it captures more organisations than people anticipate. So it's not just the true labour hire companies, where you are supplying labour to other companies in partnerships, in cooperative centres and the like. You can often end up being technically a labour hire company under the labour licensing laws. I'll skip over portable entitlements. Maximum term contracts, so fixed term contracts, as best we know at the moment, are going to be capped. There'll be a limit on the number of consecutive contracts that you can have, and there'll be an outer limit of 24 months. Now, there'll be in one of the policy documents, there's a buried reference to there'll be some exceptions, but we've got no guidance on what they are. But to use an example, we have a number of clients in the higher education space who have 3-year grant-funded employees who currently might have three-year contracts. And in one sense, there's nothing illegitimate about that. It reflects the fact that that's all the funding that is provided. I think that's the sort of area where the government is going to have to look at exceptions rather than pretending that they're continuing employees with unlimited funding. The last slide, well, there's quite a bit in it. Enterprise bargaining. I think Albo, it's like he's my friend, I think Albo sees himself as a bit of a hawk. He wants to bring the employers together with the unions. He wants to have an employment summit, and they've already talked about doing that, to look at ways in which there can be that win-win, that productivity increase, that salary increase. There's some more functional changes. He wants to give the Commission broader powers to arbitrate disputes, and we have seen protracted disputes. You're probably aware at the moment that with some very limited exceptions, you can ask the Commission to conciliate and assist, but the Commission can't arbitrate outcomes in bargaining. Preventing unilateral termination. So we have seen in some industries the only way to drive significant reform was to terminate the existing enterprise agreements after expiry. That will be prohibited. So all that we will see is a ratcheting up of subsequent enterprise agreements. Multi-employer bargaining won't affect most people in this room as best we can tell. It will be for those lower socioeconomic industries predominantly. So we think cleaning, security, those areas where traditionally there hasn't been a high prevalence of enterprise bargaining. There's a bit of a sleeper issue in there, thanks to one of my clients who pointed it out to me. The so-called zombie agreements or work choices agreements. So we do have situations where an agreement made, say, in the mid-90s, still sits there, still applies, still operates to exclude the award, and there's going to be an effective mechanism to terminate those. That's the extent of the detail we've got at the moment. But for those organisations who do have those instruments, you obviously need to be proactive and think about migrating them to other agreements, putting in place new terms and conditions. Wage theft, Dan's spoken about. Superannuation is really a corollary of that, making sure that the Fair Work Ombudsman and the courts can enforce that. The last two things I just wanted to mention are the behaviour at work. Most of you in the room will be familiar that there was the Respect at Work report, the Kate Jenkins report, and the Coalition passed some legislation in response to those recommendations, including making clear that sexual harassment was serious misconduct. The key change, though, and there's a number of further recommendations in there, but the key change will be a likely amendment to either the Fair Work Act or the Sex Discrimination Act or both to make clear that there's a positive duty on employers to take reasonable and proportionate measures to prevent sexual harassment. A lot of our clients, very sophisticated clients, have really good policies around dealing with complaints of sexual harassment, good investigation processes. We're probably lighter on the front end prevention, the cultural piece, the risk mitigation plan. And so one of the practical issues will be the need for organisations to do that OHS-led risk assessment of where are the psychosocial risks in our business, where's the higher risks of people being sexually harassed, where are those power imbalances, and then in consultation with staff, with HSRs and unions, working out a risk mitigation plan in relation to those matters. Increased reporting, again, I'm on a board. I'm going to see an increase in reporting of things around these matters and a personal liability in all likelihood attaching to these matters. The last one there on the slide is relevant to some people and fairly critical to some people, but the abolition of the ABCC, and to a lesser extent the ROC. There is obviously some concern in the building and construction industry in particular about what that will mean in terms of the cultural shift that we've seen with that very powerful regulator. Andrew Stewart, one of the academics in our area, posited the other day that the other key thing, which has had no airplay at all, is, and I don't know whether this is going to happen, but the reform of the commission. There's obviously Tony Burke's the new minister. He's probably been the most vocal critic of the employer-based appointments to the commission. And Andrew Stewart suggested that the easy way for the Labor government to deal with that is to split the commission and have a commission and essentially a Fair Work court, but comprised of some common members. For those who are old enough, we did used to have an IR court that attached to the federal court. So it would be essentially a one-stop shop, a medical super clinic equivalent with a commission bit where you go and conciliate, work things out, and then if you can't do that, well, you can go next door and someone actually is empowered to exercise judicial power and fix your bullying, fix your sexual harassment, fix your unfair dismissal, fix your general protections. It has merit. Our Federal Circuit Court and our Federal Court are completely overloaded. They're not just for COVID. And a lot of the matters don't really warrant that level of judicial attention. So that's the sort of left field suggestion. They were the things we're going to cover. I know there's a lot of content in there and I've gone through that quite quickly. Very happy to take any questions, either or to any of the members of the panel about any of the matters we've covered. Anyone have any questions? No? Yes.
Does the crossbench or Greens have any views on any of those matters that we're aware of? Yeah,
so obviously the fact that Labor now have a majority in the lower house means that a lot of the so-called teal independents and some of their views will be less critical. The balance of power essentially will sit with the Greens essentially in the Senate. You can probably glibly summarise it by saying they support the Labor position, but they wanted to go further, particularly in relation to things like insecure employment and the gig economy. There is a paper that Adam Bandt has put out about some of these measures. Unsurprisingly, stronger laws about wage theft, the old chestnuts about making businesses more accountable and ensuring more taxes paid here in Australia to support Australian employment. But I think the key issue is really around the gig economy, casual employee, and essentially removing difference in cost as an incentive to pick a particular employment model. If they're all cost neutral, if the casual and the gig economy worker have the same level of employment-based entitlements, then the capacity for misuse, the capacity for exploitation is significantly reduced. Any other questions? Everybody wants a drink, which is understandable, because we do appreciate it is an effort to physically get in a car these days or a public transport and come to the city in particular, and with the weather at about 2 degrees outside, we do appreciate you coming in. It is great to see so many of you. If you do have any questions, we will be loitering, but we'd love to have a drink and a bite to eat, and encourage you to stick around if you can. Obviously, we understand if you can't. For those at home, thank you for your participation, or at work. Thank you for your participation. I suspect you're probably at 4 glasses in by now, so probably much more entertaining at home than it has been here. So thank you for attendance, and we look forward to seeing you at the next one.